Welcome, everybody, to episode 3 of Barclay Damon's Labor and Employment Podcast. I'm Rosemary Enright, filming live from Studio B, and I'm joined by my dear friend and colleague, Mike Sciotti.
Hello, Rosemary.
And Mike is in Studio S, just doesn't have the same ring to it, Mike, you know?
We're in Mike's office.
All right. That's right. He's in Mike's office in Syracuse, New York. That's right. So as I said, everyone, episode 3, today we're going to be talking about employee handbooks. It's that time of year. So, episode 1, we talked about what's happening with the minimum wage and salary thresholds. Episode 2, we hit on the Trapped at Work Act, which was new. We were actually going to do employee handbooks, but we thought, wow, lots of questions coming in. It had only been in effect a few weeks, so we thought we better cover that. So now we're going back to employee handbooks because start of the year, new year, new handbook, maybe. So we'll chat about that. And Mike and I expect this to be 2, possibly 3 episodes. We'll see. But before we start, Mike, we've got the infamous question. So are you ready?
I'm ready.
All right. So the question today is your most memorable meal.
I know this. The first time I had Wagyu steak in out to dinner once, I had never ordered $100 piece of meat before to eat, and it was worth every penny.
Really? Did it just melt in your mouth, Mike?
Yes, it did. It was the waiter talked me into it because I was hemming and hawing, and he's like, no. He said, you need to try this. And he said, not just because it's the most expensive thing on the menu, which it was, but he said, you will understand why it costs so much once you have it. And amazing.
Wow. All right. Well, that sounds awesome. Well, I'll tell you quickly what my most memorable. So it's kind of in the meat front also, beef, but I was in South Africa, and we were doing a safari on foot. So they take you out into the, I think they call it the Veld, VELD. So it took us 150 miles out and left us out there. We had a gentleman who was the cook, and then we had the tracker, and there was another gentleman who had the gun, and then there was a group of 10 of us. And there, no running water, no electricity, and the cook, the chef, prepared the first night oxtail stew. So I'd never had oxtail in my life, Mike. By the way, delicious. I'm sure it's nothing like your $100 steak because it's an ox's tail. So let's be honest. But it was there was something about watching him cooking this entire meal over the fire, and then we all just sat in these like wooden chairs with our plates of oxtail stew. And I tell you, it was under the stars because you're out in the middle of nowhere. It was probably one of the most memorable
That's
meals.
awesome.
Yeah, it was fun. It was fun. So anyway, so hopefully we'll get all of you thinking about that too, about your most memorable meal. So with that said, Mike, let's jump in. So 2026, I got to tell you, Mike, I don't really think there's anything new that our dear listeners have to worry, or not worry about, but that they need to be adding to their handbook per se.
Yeah, I agree. Nothing yet that is going to be new for 2026. And even 2025, Rosemary, was pretty quiet year because I think it was just the prenatal leave that it was a recommended policy that you add. I will warn everyone, the New York State mandatory sexual harassment prevention policy, there's a provision in the law that says to the Department of Labor, you must review it every 4 years. So it came out in 2018. We saw the First Amendment in 2022. Here we are. It's 4 years later, 2026. Doesn't mean they will revise anything, but I think towards the summer, in the fall, we need to be on the lookout for revisions to that sexual harassment prevention policy, potentially maybe changes in the training requirements, changes in the complaint form. And obviously we'll be doing a podcast if that occurs, but that's what I see on the horizon as of right now.
Yeah, and I'd like to add or build on that, Mike, with the sexual harassment policy, and that is I've noticed I've already gotten a couple of handbooks that my clients have asked me to look at, and I've seen in their handbooks quite a few have the sexual harassment policy from 2022. And the response is, well, or actually, no, we got to go back. So it would have been the one
Yeah,
before that, right? The
right.
one before that, yeah. And they're like, well, it's basically the same. It's from New York State, Rosemary, and yeah, for our listeners, if you can see, Mike's shaking his head, no, very different,
Yes.
very different. Yeah,
Yeah, and the 2022 version added things such as bystander, intervention, and other bells and whistles. It is different. It is broader. There's more to it, and it gave other examples of things that that could be deemed harassment under New York state law that are simply broader than what you would normally think of as sexual harassment. I know one of the examples they added was a room full of men salesmen, and there's one woman salesman, and the head salesman tells the woman, "Hey, go get coffee for all of us." That is sexual harassment under the policy, and that wasn't in the first version of the draft of the first version that they published in 2018. So every time this comes out, I take the position, adopt the state's policy. I don't want you goofing around and trying to edit it down, and make it an appendix to your handbook as opposed to clogging up 15 pages in your handbook with it. Have it as an appendix. So whenever it's revised, you simply go in and put the new version in. Now, I have seen this more times than I can count. They put out there the new version in Word, and the company downloads it and puts it in their handbook. But there's only one problem. They didn't revise it. They didn't put their company name in it, any contacts, and they didn't own it. And you have to own it because the state gives you a generic policy, which you then have to revise and make your own. It's not simply a cut and paste. It is a cut and paste, but then you have to edit. So just be on the lookout for that. But it does make a difference. And I also think, Rosemary, the Division of Human Rights or the Department of Labor, if they see the old policy, would say you're not in compliance. And my concern would be in a sexual harassment case, does the fact that you're using an old policy that is not currently in compliance with the law, does that create a material question of fact to get a case automatically to a jury? I'm from a Division of Human Rights perspective, I think they're going to find probable cause and kick it to a hearing. So be careful. We got to keep the handbook is something, Rosemary, that needs to be reviewed and, if needed, revised yearly. It also needs to be redistributed yearly. And the reason I make that last comment is the New York blood donation leave law and regulations and guidance state that you must redistribute the policy every year. So if you have to do it for that policy, do it for all of them and keep getting the sign offs, which we're going to talk about, especially the recalcitrant employee who just refuses to sign. Get those sign offs yearly. This is the handbook I preach is your front line of defense. And if it's not correct, you're going to have issues. Now, what those issues are and how it rolls, it will depend on what the claim is, but we have to get it right.
yeah. And I want to add, I want to make 2 points, and so just 2 points, and feel free to comment on these, Mike. The first is, I just want to make sure everybody's clear. When Mike says you've got to revise or own, make it your own, the sexual harassment policy, I'm going to put a finer point on that. What he's saying is, if you look at the model policy, it'll have a field and it'll say company name in parentheses. So I like you, Mike, have seen many of these where they say, here's our policy, and it says company name, blah, 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 blah. And then it says insert name of person. Okay, well, again, the DHR is going to say you're not taking it seriously. What is an employee supposed to do? Or an intern or a volunteer, when they see this, they don't know who to go to. You need the name. So when we say make it your own, revise it, that's what we're talking about. Fill in those parentheticals, and if, whatever your process is, go to this person, do that, that's what has to go in there. So, but don't change any of the other language. That's the model policy for a reason. The second point I want to make, and I'd be curious, Mike, and your opinion on this. So I agree with Mike. Put it as an appendix. So right now, I think the current length is 12 pages, right, Mike? I think it's,
Right.
I think the model policy is 12 pages. So all of a sudden in the middle of your handbook, you've got these 12 pages. So I like the idea of putting it in as an appendix, but you need to have a reference in the actual, in the body of the handbook that says, sexual harassment. And you've got something there. And so what I always say, Mike, is state it's a violation of, company policy, state and federal law. And you don't have to get into all the definitions, so it's 2 or 3 sentences that just kind of encapsulates what we're talking about. And then we refer them to the appendix. Because again, if it's not in the section where you've got your discrimination, for the reproductive rights and the general discrimination policy and harassment policy in that section, then they're asking, well, somebody might not know, where do I find it? And crazy as it sounds, I mean, your employees, if you give them a big handbook, they may not even realize there's an appendix, or they may not look at the appendix. So that's generally what I advise. Mike, I don't know if you agree with that.
I agree, and would add the following, just to sort of put a finer point on the policy. Don't try to make the sexual harassment prevention policy cover all types of harassment.
Agree.
Leave it as sexual harassment prevention, and
Stand
then
alone.
and then have a non harassment policy which covers everything else. And that one could be a lot simpler. Have the complaint procedure in there, who to complain to. This covers age-based comments, race-based comments, military comments, whatever the other protected classes are, and there's a lot of them now. So, I would have two. I think it's very important not to try to combine them, because what I see is the employer tries to combine them, and it waters down the policy, and sometimes I have a hard time following what it is they're talking about, because they added 2 paragraphs, and then suddenly all they talk about is sexual harassment. So be careful in relative to that particular policy, and how you do it. And I do think you need both. I think it is in 2026. It is well within everyone's purview. You must have both. And if you don't, I think the division, the EEOC, a court, a judge, a plaintiff's attorney, a plaintiff, all of them they'll notice it. And they can, not having a policy can be used against you.
Right, exactly. Which is why when I was saying it, I said reproductive rights, non-discrimination and harassment, because right there, that's exactly right, Mike. Always make them separate. Always make them separate. So we got down the sexual harassment and, prevention policy, which is very important. All right. So Mike, let's take it, I guess we'd say take it up several notches, and let's just talk about generally a handbook itself. What are some of the general, I'm not talking policies, but things around a handbook for people to stop and think, oh, that's a good idea. I didn't think of that. I should do that, or I shouldn't do that.
Yeah, number one, I think, and some of these are real simple, page numbers. Sometimes employers don't have page numbers in their handbook, and you should. You should have an effective date that the handbook takes effect. So, either on the first page or maybe have a footer at the bottom of every page, effective January 1, 2026, so we know exactly what version we're dealing with, and make sure you save the old versions because you have an obligation to preserve those. A table of contents, some type of numbering system for the policies. I see, section 101, 102, 103. That's fine. I don't care how you do it as long as it makes sense. And then a acknowledgment page. I have received, read, understood, and agree to follow this employee handbook, and make sure you get that sign off, which we'll talk about in a minute, I'm sure. But
Yeah.
just some general things that people sometimes overlook, or I see problems with the handbook, and then if you're doing a cut and paste, okay, I get worried. You're using someone else's handbook. It needs to be thoroughly edited, but you need to do your own due diligence. What laws apply to you? What is your gross income? How many employees do you have this year, last year, per pay period? Do you have a union? Do you don't have a union? Do you have employment contracts? Do you don't have employment contracts? Are there unique employment laws that apply just to your industry? Are there unique safety rules that apply just to your industry? And just as an aside, I'm okay with a separate safety manual if you're like in a highly regulated area. I think the same general rules should apply, because if there's ever, hopefully not a death in the workplace, OSHA's going to say, "Where's your safety policy manual?" And they're going to want to see it, or your safety policies. So really owning the handbook by looking at the various coverage tests to determine what applies to me, and then keeping it up to date. And one of the zingers here is, where are your assets? Where are your employees? Because here in the great state of New York, we have local labor laws. Buffalo, Rochester, Syracuse, New York City, Albany County, Westchester County. We have to make sure that we are not only complying with federal and state, but any local laws. And if you have assets in another state, you have another decision to make. Do I have a master handbook and then maybe state supplements? Or do I do separate handbooks for each state? I don't care. You just have to be consistent and be able to keep them up to date, and make sure the employees never have a dated handbook. So let me pause there and let you talk a little bit.
Yeah, no, that's fine, that's fine. So a couple of things, to your point, Mike, when you were talking about, there's an effective date on it. So I've had several employers who will, and I've gotten the handbook, and, they've been doing it for years on their own. They said, "Hey, we thought you should maybe have a look at this." And then I see down at the bottom, revised, or at the top for a policy, revised on this date, this date, this date. And what they're doing is, they're just, and I think you made this point, but let's just make it even clearer that they're updating it. And like you said, the other version is gone. Well, if this says this is version 5, or it was revised 5, in 2020, 2023, 24, and 25, well, what was it in those prior years? And what was it revised to? Yeah. And so it's very important. And I know a lot of you may be thinking, "Oh my gosh, we got to keep all those versions." The answer is, yeah, you do. You do, you
And
know?
the other thing I would find confusing, one of the things I look at handbook as, if I was the government
Mhm.
or plaintiff's attorney, how would I view a policy? And if it said 4 revision dates in 4 different years makes me ask a question, just like you said, what were those?
Yes.
Is it going to open up new areas? It's best that you don't do that.
Yeah.
Now, you can have in human resources, like a master handbook that says we made these revisions on these dates. That's fine. I wouldn't distribute that to the rank and file. I think that's an internal management document for purposes of keeping track of the handbook over the course of a generation. And I'm fine with that, but I just think I find it confusing when I see that, and it begs a lot of questions.
Precisely, which is why I brought it up because I've seen it many times. Two other things, Mike, as we're chatting. So we're talking about the acknowledgement, which we'll get to that point in a second. But we're talking about distributing. Okay, thoughts on, okay, so we don't have a hard copy. We want to do this electronically. Can we do that? We get that question all the time. Can we do it electronically? How do we do it electronically? And so go ahead. What's your response to
Yeah,
that?
the answer is sure. And I don't care if you do it electronically or the old-fashioned way. To me, it makes no difference as long as I have a John Hancock, a signature, an acknowledgement from the employee. It can be a wet signature used with his actual handwriting or an electronic signature, where I've seen a couple different versions of, like, when you check out with a credit card, you actually sign your name. That's one version. And another electronic version is you type your name. And some employers have PIN numbers, and each employee is only allowed to type in um, their name electronically if they also type in their PIN number, which they were given by HR. All those things are good. You don't need to have paper anymore. Electronic is totally fine in my opinion. Here's what the government requires of you: that if you do it electronically, you have to be able to, one, find it, two, print it out, three, that it looks like the original, and four, that you're able to verify the signature. So, if you can do all those things electronically, fine. I think it makes your life a lot easier.
Yeah, I agree. Well, and the other thing I'd say is if you happen to be an employer all of your employees don't have their own computers. So you've got a manufacturing plant or something. So the question is always, what do we do with that? And the answer to that is you have a bunch of computers that are set up, which you should anyway, that those individuals have access to. So they can access to the points that Mike just made. They can easily access the handbook. They know I can go and use that computer that sits outside the HR office, or it's in the break room, or it's in both of those places, and I can log on, I can access the handbook, I know how to access it, I can download it, I can print it. And so
Exactly.
that is absolutely fine to do. Now, what do you do about the person who, as you said, Mike, we can't get to sign the acknowledgement?
Yeah. So I think there's two categories, Rosemary: the new hire and the
Mhm.
existing employee. Let's start with the new hire. I am of the belief that a new hire is not allowed to actually work until all paperwork has been completed, and that includes successfully completing the I-9 form. I know you got 3 days. I don't care. Every form is signed, sealed, and delivered before they go to their desk. And if they refuse to sign the handbook, I won't let them proceed. I'm going to
Right.
say, sorry, you can't work here if you don't sign off on the policies. I think that's not the new employee, and that's a little harsh because I know you need workers, but I think it's also a red flag that this person is going to be very difficult. And, sometimes we get people that don't wanna sign their withholding forms or don't wanna give, identification for the I-9. Sorry, you can't work here. I think the existing employees is a little different, not by much. The HR function has to hunt down anyone that hasn't signed. And, And by that, I mean, call them in your office. Say, you have not signed off on the handbook. I need you to acknowledge it today. No. Okay. Here's and everyone laughs when I talk about this. Here's tip number one. Can you please write refuse to sign? Try to do it with a straight face. And sometimes the employee will write refuse to sign and date it. That's an acknowledgment. Then you write a little, this is Johnny Jones, and Johnny Jones signed this into my presence. Usually they'll laugh at you when you say that to them. But then you say, okay, this applies to you. You sign Johnny Jones. I'm signing on behalf of Johnny Jones. He refused to sign in my presence on such and such a date, and put it in the file. Maybe have another witness of a management employee. I've actually had some employers that have said, you don't want to sign? Okay, we're putting you into an unpaid leave situation until you decide to actually acknowledge it.
Really?
Yeah, and they
Wow.
don't mess around. And I've never thought through the legality of that. At first blush, to me, it appears legal. But I think you want to think about that and before you do that. Again, you need workers, and what are you buying? I mean, you're really now irritating the person, and he's probably never going to sign. And I've actually had one employer do this, Rosemary, and again, try not to laugh. They took the handbook, sent it in a plain envelope, return receipt requested, delivery to the employee only, and they got the employee to sign the return receipt card, and he opened it up, and it's the copy of the handbook because he was being
My God,
difficult.
that's awesome.
So, there's lots of ways to skin a cat, but I think that those are generally just like employee refuse to sign, and don't go crazy with it. The other thing, remember, if you need to add or modify a policy, you can do so at any time during the year. And I don't think it's necessary, Rosemary, to redistribute the entire handbook. You just say, this is policy 101. It replaces existing policy 101 effective June 1. Please sign your acknowledgement. And I would say give that out with the paychecks, and try to get a signature. Don't hold their paycheck. I'm not saying that, but usually you can get it, and then you have to hunt the individuals down that have refused to sign. Because I tell you, everyone that's listening to this, the people that usually refuse to sign are going to be your plaintiffs, and you're not going to have the signed policy. So that's why I'm paranoid about it.
Yeah, yeah, yeah. I love that story about the certified. That's awesome. That is just awesome. Um, so we're talking about all this, and so let's say we have a listener, and they're sitting there and they're thinking, well, you know what? Why even bother then if I have, I've got to worry about somebody signing, and I've got to distribute it every year. I mean, let's just skip having a handbook. I mean, is there, and I get this question all the time, is there a law, Rosemary, a state or federal law that says we must have a handbook? And the answer is no. There's a law that says every employer with X number of employees must have an employee handbook, and this is what it must contain. And so the answer so then they'll say, well, then I don't know that I really want to do it. So what's your response to that, Mike?
There's a series of policies out there that are mandatory. They don't have to be in, quote, a handbook, but you have to have them. So we've already mentioned one, the sexual harassment prevention policy. If you're FEMLA covered, you must have a FEMLA policy. For those of you in New York, we have the Paid Family Leave Act. You must have a policy. You must have a New York State sick and safe leave policy. So there are all these mandatory policies out there that, to me, call for only one sign off. The reason I say put them in a handbook, you get one signature, and that takes care of them all. Otherwise, if you have 10 separate policies, I'm going to ask for 10 separate sign-offs, and that's a lot to keep a track of. So it's the reason for it is you're dead on. There's nothing that says you must have a handbook. What they say is you must have this policy or this policy or this policy. And then there's a second group, things that are not legally required, but highly recommended. A code of conduct, what we expect the employees, how to act and how not to act. Those of you that have had unemployment hearings, did you ever warn your employee that you expected them to show up for work on time? First time I heard that, I sort of chuckled. I said, seriously? Yeah, put it in your code of conduct. And then you can say yes, and he signed off on it. So there's that second tier, highly recommended, because it is, as I said earlier, your front line of defense. And let me be frank, I don't think most employees read the thing cover to cover. I just don't.
I agree.
So you can have buried in there all your policies, procedures. This is how you complain. We can use the handbook against them in the event we get into litigation. And that's really, to me, the litigation rationale for having a handbook. I hear, Rosemary, that sort of as a follow up to yours, why should we have a handbook? And then they'll add, I don't want to educate them.
Yeah.
I don't want to give them any ideas. Well, for the mandatory ones, you have no choice. You have to put them these things in writing. But putting ideas in their head, they already have them. Go to Google, workplace discrimination. They will be educated. We now have plaintiffs writing books on how to sue your employer for employment discrimination. So this is the handbook is simply a way to counteract that. And yes, it's work. And yes, the HR function needs to stay on top of it. But I will swear up and down that having a handbook is better than not having one any day of the week, as long as the following occurs. It's correct. Because if you have an incorrect handbook, it's worse than not having one.
Much
And
worse.
it will come back to bite you if
Yes.
your handbook is bad.
That's exactly right. I couldn't agree more. And I think, Mike, that's a good place to stop for this first episode. So, thank you all for joining us. As we say at the end of every one of these, please check us out on Spotify. Share any of your comments, questions, give us ideas about what you'd like to hear about. And Mike and I will reconvene for another episode to continue our discussion on employee handbooks in 2026. Thanks, Mike.
Thank you, Rosemary.
The Labor and Employment Podcast is available on barclaydamon.com, Spotify, and all major podcast platforms. Be sure to like, follow, and stay connected for future episodes.